morning, Mr. Sonic. Good morning, everybody.
Good morning, Chairperson.
Are we ready?
We are ready.
Okay, all right. Let's start. Good morning, Ms. Peters.
Good morning, DCJ.
Yes. The oath you took yesterday will continue to apply today.
Thank you.
Okay, all right.
Ms. Peters, you'll recall yesterday it was said that if you have your mask on, it gets muffled. Sorry about that. Ms. Peters, again, just to orientate you, I'm just going to ask you a few more questions about the appointment of the CEO, and then I'm going to go on to the other two matters that I raised with you yesterday, namely the attempt by, or the allegation by Mr. Molefe that you attempted to stop the Werksman's investigations, and then the dismissal of the board by yourself. Before I deal with those two topics, though, let me just get back to the question of the appointment of the CEO. We know that from the time Mr. Montana left on the 15th of July 2015 until the end of March 2017, when you were relieved of the position, there was no permanent CEO appointed. That's correct, isn't it?
That's correct, Chair.
In the meantime, there were acting CEOs.
That's correct, Chair.
One of the issues, forgetting the other matters you raised, that you said had in a way hindered the appointment of the CEO, was the fact that you wanted to approach the president before the matter went to cabinet, or before your recommendation went to cabinet. You remember that?
Yes, Chair.
Now, you had a recommendation prepared for cabinet.
It was not yet prepared, Chair, like I indicated yesterday.
Can I ask you this? Had you identified the three persons that you would recommend to cabinet or to the president before it went to cabinet?
The three persons that would be put into the cabinet memorandum would have been those that the board had recommended, Chairperson.
This is the recommendation that was made around the end of 2015.
I don't remember whether it was the end of 2015 or early 2016, Chair.
Okay, but you didn't change those recommendations.
I was not going to change them, Chairperson. Like I indicated yesterday, we had the bundle from...
No, we've been through that, and I don't want to stop you, Ms.
okay.
Peters. We need to get your evidence. You said to me before we started that you want to be in Parliament. Can I guarantee you that you'll get to your flight? Now, I'm just trying to keep my promise to you.
Thank you, Chair.
Right, so now when Mr. Montana left, we know that Mr. Zide was appointed as Mr. Kenna was appointed as the acting CEO.
Correct.
Who appoints the acting CEO?
The acting CEO was appointed by the board.
No, I'm not asking in this case. Ordinarily, who would appoint the acting CEO?
Ordinarily, the acting CEO would be appointed by the board.
And without consulting you?
They would, once the board had taken a decision, would consult with the minister as the shareholder responsible for the sector or for the industry.
So, if the board recommended, we'll say, Mr. Zide instead of Mr. Kenna, you would have said to the board, no, I don't want Mr. Zide, I want somebody else, and they would recommend Mr. Kenna. Is that the position?
Not necessarily, Chair, unless there are factors in my knowledge that would really be presented to the board that says, for these particular reasons, this is the reason why this individual. But in this instance, it never happened.
But you would have a veto power over the board, even in regard to the appointment of the acting CEO.
I won't say it's a veto power, Chairperson.
Before the board appointed Mr. Kenner, they consulted you. That was the process, and that process was followed in this case.
They appointed Mr. Kenner and informed me.
Now, I'm asking a different question. Before they appointed Mr. Kenner,
There was a vacancy, and the board, when they came to inform me of the departure, or actually not the board, the chairperson, when he came, he didn't come, he called me to inform me of the departure of the then CEO, the group CEO, and that the board had taken a decision to appoint. Obviously, they would not allow for a vacancy, a vacuum. They appointed an acting.
did you consult the president before you responded to Mr. Molefe's request or communication to you?
In instances of acting, it's not part of the cabinet protocols that allowed for that, because it's an emergency, it is a stopgap measure that you are putting in place. So there is a process that will then unfold. After that, I then informed the president that there has been this situation at PRASA, and the board has appointed an acting, and the process of the appointment of the CEO would then unfold.
Which didn't happen, though.
It didn't happen immediately, Chair.
Well, it didn't happen at all. We don't even, throughout the period you were there was no CEO, and no attempt was made to take that matter to cabinet.
Chairperson, the consultation process is part of the attempt to get to cabinet.
Yes. Okay, I just wanted to pursue the point because you raised it. Now, you say the appointment of an acting CEO is a stopgap measure. This was a measure...
I'm sorry, Mr. Soni, I'm sorry. Please don't forget the question you wanted to put to Ms. Peters. But the position, as I understand it from your evidence, is that by the time you left, you had not even commenced with that consultation process, isn't it?
The matter had not as yet now arrived at cabinet. Chair, you would remember yesterday that I indicated that part of the consultation process, even with cabinet colleagues, helps you to arrive at the point that strengthened your case towards cabinet.
I understand that part. The reason why I'm asking you this question is because Mr. Soni said to you, by the time you left as Minister of Transport, the issue of the appointment of the CEO had not been taken forward. And I understood you to be suggesting that the consultation had started. And that's why I want clarification, because my understanding is that in your mind, you may have been planning to start the consultation, but it actually had not started. Is that correct?
Yes, Chair.
Okay. Thank you. Mr. Soni?
Thank you, Chairperson. So after Mr. Kenner was appointed, you informed the president about his appointment, or that the board had appointed Mr. Kenner?
I reported that as part of my reporting process, that there is this particular situation that is prevailing at PRASA, and the process, like I indicated to you, Chair, was now we would be starting with the process of going towards appointing the full CEO. And for me, Chairperson, it was a principle that I believed in is correct. You have a head of state that all these entities, all these departments actually report to him. And it is important that he then know what is happening. And I believed, Chairperson, like I indicated yesterday, maybe my history and my experience in the previous positions that I had held informed me on this particular approach.
When Mr. Kena left in July 2016, Mr. Letswayo was appointed, is that correct?
Yes, Chair.
Now, did you inform the President about that?
I wrote a report because at that particular time, there was a lot of activities or a lot of things that were happening in the country. And so I wrote a report to the President. And Chair, I think, if I'm not mistaken, that report is part of the package or documents that you might have received. If I'm not mistaken, I will just check on it.
So when Mr. Kena was appointed, you told the President when Mr. Letswayo was appointed, you wrote a letter. I'm just trying to understand the differences in processes.
Yes, Chair.
When Mr. Letswayo was then removed by yourself on the 3rd of March, and we're going to come to that in a moment, 2017, Mr. Zide was appointed. Is that correct? Did the board not tell you that?
At that particular time, Chairperson, like I indicated, I had episodes of ill health. So I would not necessarily follow the actual sequence of what happened, but I know that there was a stage where Mr. Zide was acting.
Now, Mr. Zide was the company secretary, is that correct?
Yes, Chair.
How does a company secretary qualify to be appointed as the CEO, albeit in an acting capacity, of a major organization like PRASA, which is incurring losses in the region of 10 to 15 billion rand a year? Not losses, sorry, which is incurring irregular expenses. We've been through that yesterday.
I think, Chairperson, the best person to answer to that question would be Mr. Molefe.
And I tell you why you can't avoid responsibility. It is because there was no permanent CEO that all these acting appointments have to be made. And it was you who, according to Mr. Molefe, were the person who frustrated the board's attempt to appoint somebody as the permanent CEO.
Chairperson, in my life and in my experience, I have never frustrated a process. And if you allow me, Chairperson, I'll just make a short example of a situation that prevailed in another entity of the Department of Transport, where we were faced with a appointment process, which when it arrived at the platform of cabinet, it was returned because one of the sister department ministers picked up that this particular individual was leaving this entity from that department because of serious irregularities and litigation issues. I'm making that as an example. And the consultation process, Chairperson, always helped us with regard to that.
Okay, all right. No, I just wanted to make sure that you appreciate that that example is not going to help you to answer this question, whether in this case you frustrated the process or not.
I didn't frustrate the process, Chair.
But certainly you didn't expedite the process.
I was working on it, Chair.
Well, maybe Mr. Molefe in his affidavit might not be specifying in the manner of saying what Ms. Peters did to frustrate the process were the following things. But it may well be that one of the things he has in mind as frustrating as you frustrating the process is when, despite the fact that on his evidence, they, that is the board, had undertaken a vigorous recruitment process and were ready with the candidate or candidates in, I think, August 2016, you said to him, PRASA is not ready for a new CEO. Why should that not be seen as an act on your part that may have frustrated that process?
Chairperson, in my discussions with Mr. Molefe, we agreed that there were serious underlying challenges in PRASA that needed to be addressed. And that was as a result of the indications from him that the then acting CEO, Mr. Kena, and was not productive. I don't want to use the word he used, and that he doesn't seem to be able to be contributing to changing the scenario that he was supposed to have changed. And that's why he then felt he's useless and he's not working together with them as the board. He even went further to say—
Does he talk about Mr. Kenna?
Yeah, that is Mr. Kena now.
Okay.
He indicated at that particular time that it was his suspicion that Mr. Kena might be drawing his mandates from elsewhere. And based on that frustration, we went the next step.
Well, I don't know whether, I can't remember whether Mr. Molefe has finished the commission with an affidavit where he responds to what you may have to say about whether or not you frustrated the process. But it would be strange if he would agree that he agreed with you that PRASA was not ready for a new CEO, and in his affidavit say you frustrated the process, and particularly when the board had done what he calls a vigorous recruitment process, one would have thought that the board would have made up its mind that there was a need to appoint a group CEO. What do you say to that?
Chairperson, I would not probably be responsible for the thoughts and the views of, or the impressions that Mr. Molefe got. But in my discussions with him as the chair and the minister, we arrived at that particular indications that they are serious problems. At that time, Chairperson, there was the issue of the AG report. There was the issue of the public protector report.
Yes, I think you mentioned those yesterday.
Yes.
I don't have to repeat
We had a
them.
meeting, Chairperson, with him and the chief procurement officer. There were a lot of things, and all of them bordered on issues of finance in PRASA.
Yes, but I thought that you and I agreed yesterday that it was not correct for you to say the CEO should not be appointed because PRASA was not ready for it. We agreed on that. And I take that to mean you accept that there was no valid reason why in August 2016, when, according to Mr. Molefe's letter of August 2016, they were ready with a name or names I take it that you accept that there was no valid reason why the appointment was not made then. Do you accept that?
Chairperson, at that point, like I indicated, that was a time the board, through Mr. Molefe, brought me the information, which the process then determines must be processed. And one of those was, like I've indicated, Chair. I must concede here that if the consultative processes that lead up to I don't want, for a lack of a better word, I don't know what to say, but gives the minister the confidence to say, this is what I can take to cabinet and stand with it, because I've done what would have been expected of me. I've checked with my sister colleagues. I've given the chair of cabinet an indication on the matter that will be before cabinet, and therefore I do have that particular confidence. The experience of also working in that cabinet has also provided me with an understanding that cabinet is not a rubber stamp. You just don't go there and say, this is what I'm bringing in.
I'm sorry, I'm stopping you because you mentioned that yesterday as well. No, look, I accept that when I say, I take it you accept that there is no valid reason why the CEO was not appointed in August 2016. I don't mean that the consultation process, such as you may have wanted to do, should not have happened. So I'm quite happy to say from August, when you were given the information, maybe you were given it earlier than that, I'm not sure, but from August, maybe another month or two, maybe that process would have been enough. So maybe I should reformulate my question and say, I take it that you accept that there is no valid reason why by end of 2016, the new CEO had not been appointed. Would you accept that?
Chairperson, sitting here, let me take responsibility for the 2 years that it took. But Chairperson, I would want to go further to say, I cannot further take a responsibility for the ensuing 5 years that PRASA still has.
Obviously. And I do want to say it's important that leaders take responsibility for where they may not have done what should have been done. Because if they don't acknowledge where they may have not done the right thing, then they can't change, they can't find the part of the solution because they are in denial. You know? So it's very important that where one sees that, look, here I didn't do the way I should have done things, that there is an acceptance of responsibility, and I accept that you accept that responsibility for the time
2 years,
before
Chair.
you left. Yeah. Okay, Mr. Soni.
Just to reinforce that, when Mr. Molefe, whenever it was, said to you he had reservations about Mr. Kenner.
Pardon?
I say, when you for the first time have told us today that Mr. Molefe expressed to you during the tenure of Mr. Kenner that he had reservations about the appropriateness of the choice, for whatever reason. You've said that today, you remember that. I would have thought that would have been a spur to you to say, we must get somebody whom we've vetted, and we must sort this problem out once and for all. Or am I wrong?
You are not wrong, Chairperson, but with knowledge and experience and understanding of the situation at that particular moment, you would have also been able to agree with me and the board chairperson at that particular time.
I'm sorry, just repeat that. I'm not sure that I follow it.
I'm saying the question that is being asked now, Chairperson, I'm saying if you have the information and the knowledge of what was happening at that particular time, you would have agreed with me at that particular time that yes, when we agreed that Mr. Mlife and the board can release Mr. Kena from the acting position, there was no way that the next morning we can appoint the group CEO, because the process had not started in terms of the concluding part of that particular process, Chairperson.
Mr. Soni?
I must say to you, Ms. Peters, we are going in circles. You've already conceded, as the chairperson pointed out to you yesterday, that when you said there were good reasons not to appoint, you conceded you were wrong. You said 2020, I remember your words, 2020 is a perfect hindsight. I mean, is a perfect science.
Chairperson, I said I conceded that it was wrong not to appoint in that period, but without going into the details on why it was not done. Yes, I still say 2020, you realize that the 2 years that it took to appoint the CEO was a long period, Chairperson. But I'm saying if you were in my shoes at that particular time, you would have arrived at another conclusion. And I am saying, I accept, Chairperson, and I cannot run from that fact, that there was a period of 2 years where there was a vacancy of the group CEO in PRASA. And I accept, Chairperson, that that period coincided with my presence in the Ministry of Transport. That one I accept, without going to the rationale and the reasons why we ended up in a situation where the appointment was not taken, was not made.
Well, out of your evidence, it may well be that telling me about those things that prevented the appointment of a group CEO, that might be the most important evidence you give.
Pardon, Chair?
I'm saying that telling me about the rationale for not appointing the group CEO for that 2-year period of 2 years or 2.5, or I'm not sure, before you left the ministry, might turn out to be the most important evidence coming out of you, because I want to understand, but I can't understand even now why PRASA stayed for, I don't know if it's 5 years without a group CEO. And of course, you can only talk for the time that you were Minister of Transport. But maybe if you tell us exactly the rationale, that might help us understand why for 5 years, or whatever the period is, such an important entity was allowed to have no permanent group CEO. It's just difficult to understand. So I'm saying to you, you might not have intended to tell me, maybe because you say because of time, but I'm saying to you, it's very important, because when I write the report, and still I have not been told anything that makes me understand, I may come hard on certain people and even on you. And you had the opportunity to explain to me, to say, Chairperson, this is why I did what I did, this is why I didn't do what I didn't do. Okay? So I'm saying it is quite something important, because on the face of it, it appears as a dereliction of duty, but it makes one suspect that there may be something sinister behind it. Why this entity that it was known by all concerned to be carrying a lot of irregular expenditure year in and year out, and about which there were so many allegations of corruption in the public domain, why was it allowed to have a situation where there was no permanent group CEO? Was it convenient for certain people that it should just be acting people? What was going on? So those are the questions in my mind. And if you can help me understand that, that would be very helpful. And it's your own opportunity to say, well, I may have been minister, but here were constraints that I was working within. Okay.
Should
If
I
you
go
want to
in-
tell me, you can tell me.
Chairperson, if I might digress a little bit. When I was appointed in July 2013 to transport, I met one person. I mean, during that period, people come and congratulate you and wish you well. But there was one that stood out that today I remember. And that person didn't just congratulate me. He said, congratulations and condolences. And now, the word condolences really is more prominent in my situation with regard to why the word condolences. I never asked him, why are you saying condolences? I just loved it and passed on. No, not passed on, and went ahead. And Chairperson, I would want to indicate that when the group CEO left PRASA, the board appointed Mr. Kenna, and like I indicated, in a few months, the board chairperson came back and said, in fact, he said, Mr. Kenna is useless and all those type of things. He is drawing mandates from the previous CEO and all those type of situations. And he had the impression that even in the organization, that is still happening. Then we went on to engage with the board because according to them, Mr. Kenna was useless. And they said that, we met with the board and the board confirmed that the situation under Mr. Kenna deteriorated and that they wanted to replace him with immediate effect.
With whom?
With immediate effect.
Oh, okay.
And with immediate effect meant that they were going to appoint an acting. They made a recommendation on Mr. Zide, and I raised a concern with regard to Zide being the company secretary. And the board chairperson made even a recommendation that one of my advisors could be the acting, and I said that person would be outside the department, because of the public service and all that, and we agreed. And I even said to him, why do you now want to cripple my ministry? And I raised that. After discussion, on the 30th of June, we had a discussion with the board, and after their consideration of all the factors that showed that the matters under PRASA was actually financial matters, I even said to them, if these matters are more financial, and they also involve department because it has a bearing on the ability of the department for oversight. There were also allegations from the department on the non-responsiveness of the management of PRASA to the issues that the department wanted answers to. Equally so with engagement that we have had with the AG, as well as the investigation that the AG was supposed to have started, and then the report of the public protector chairperson, and all those particular things. And at that particular time, both myself and Mr. Molefe agreed that PRASA is not ready because there's all these many problems.
Well, let me stop you there, Ms. Peters. What you have been telling me for the past few minutes is what happened after Mr. Molefe had left in terms of who was going to act and what. A lot of that you did mention yesterday. I thought you were going to tell me when you said you didn't go into the rationale why the group CEO was not appointed for quite some time. I thought you were going to tell me something you haven't told me, namely,
I'm coming to
here
that.
are the things that made it difficult for me to ensure that the Group CEO was appointed without delay. I thought that's what you were going to tell me.
Mr. Chairperson, in the discussions that, like I indicated earlier on, if I have to backtrack, that the bulk of the issues that were a source of concern and problem in PRASA were financial.
Yes, but that would not make it difficult for you to get a CEO appointed. That would be all the more reason why you should get a CEO appointed.
I agree, Chairperson.
Yes.
Like I indicated, Chairperson, with hindsight, I agree.
Yes, yes.
But at that particular moment, there were things that we were dealing with the Chairperson.
Yes.
And I'm very sorry, and I feel aggrieved that the chairperson of PRASA, after our engagements throughout those processes, he came to the commission to want to project that particular delay of appointing the CEO as the reason for him to believe that I was creating an environment for the company to be captured.
Well, let me leave out the question of whether he presented evidence that suggests that you did something to enable the company to be captured. Let me leave that out for now. What we do know is that for about 2 years after Mr. Montana had left, close to 2 years, that is from when he left to when you left the ministry yourself, that was close to 2 years. The group CEO was not appointed. That we know. What we also know, because you don't dispute, is that the board, according to the letter that Mr. Mulefe sent to you in August 2016, had engaged in what they say was a vigorous recruitment process to have a group CEO appointed. And that they even had a name or had names, 3 names. And they had given these to you. It was up to you to take that process forward. We know, because you have given evidence to this effect, that you did not take that process forward. We know that you say in your mind, at least in 2017, no, we know that I think up to the end of 2016, based on your evidence, you were still of the view that PRASA was not ready for a group CEO. That's my understanding of your evidence yesterday. But I think you said early in 2017, you changed your mind. So based on that, who would you say prevented the appointment of a group CEO at PRASA between August 2016 and the time when you left the ministry?
If the chairperson says who,
I'm sorry,
chairperson.
I'm sorry, Ms. Peters. I'm saying prevented, but that might not be the right word. But the ball was placed in your court by the board, and you didn't do what was necessary to be done in order for the group CEO to be appointed. Would you accept that?
Chairperson, even at the point of appointing, after Mr. Kena, the CFO of the Department of Transport, Mr. Collins Litwalo, into PRASA as the acting group CEO, we continued engaging with regard to the fact that the direction to recruit, not to recruit, to get to the appointment of the CEO must continue.
Yes,
And we were busy with it at that particular time.
Yes, but-
And Chairperson, I did indicate that after receiving the bundle from Mr. Molefe, we were busy with the process to say this matter must then be processed into a cabinet process. Whilst it is being processed, at the same time, I'm busy also engaging consultatively with the relevant stakeholders. And in this instance, the most important relevant stakeholder for me was the head of state, because he was the chair of cabinet, and I needed to inform him that we have now arrived at the board having taken a decision to appoint. And that particular slot we have not yet arrived at.
But why should it take 7 months or so, that is now from August 2016 to March when you left 2017, for you to consult the head of state or your colleagues? Why should it take so long?
Chairperson, from around the 1st of July up until some time into 2016, you would remember, Chairperson, in this country, it was local government election time, and most politicians are involved in those particular processes. And equally so, my opportunity to sit down with the president would then have to be slotted into that particular process.
No, my recollection is that the local government elections happened before August 2016.
It was on the 6th of August, 2016.
Was it on the 6th of August?
And-
That was early
that-
in August.
That was a day of the elections.
Yes.
And after the elections, as political parties, there's protracted engagements that is involved, and it involves the key leaders in the party as well as the president and other role players. So,
But that can't justify taking 7 months, can it?
Pardon?
That can't justify taking 7 months.
It cannot be divided into 7 months, Chairperson. Earlier on, I considered that it took long. But in between the work of engaging with regard to matters of PRASA, we are also engaging with regard to other matters of other equally important departments that equally contribute. So I was not seized solely with the responsibility of a PRASA, Chairperson.
But
At that particular time, Chairperson, you would remember, I was part of a panel with the Deputy President to deal with the challenges that were raised with regard to the e-tolls in Gauteng, a meeting that we held on a daily basis.
that's, well, I don't necessarily remember that, but the fact of the matter is the ball was placed in your court by the board, by giving you the names, giving you the files, and you didn't take the matter or the names
To cabinet.
to cabinet.
I agree, Chair.
Whatever explanations you have, that is where the whole thing got stuck.
Yes, Chairperson.
Okay, all right, Mr. Soni.
Thank you, Chair. Ms. Peters, then, just so that when the chairperson needs to work out where accountability should lie for the non-appointment of the CEO, you've told the chairperson everything in your defense. You've set out everything you want to set out. There is nothing more that the chairperson needs to take into account. Is that correct?
Like I indicated,
No,
that
it's a yes or no. But if there is anything more, tell us what it is.
Chairperson, like I said, I indicated to the chairperson that I take responsibility for the 2 years of lack of appointment of the CEO of PRASA for reasons that I have laid before this commission.
I want to get on with something else now. Can I ask you to look at Bundle D? This is Mr. Molefe's affidavit it's SS6, Chairperson, page 25, paragraph 95. Bundle D. page 25 on the right-hand side, paragraph 95.
Twenty-five,
Yes,
paragraph.
95, right on the top. It says thereafter on the 12th of August 2016. Do you see that? Do you see that, Ms. Peters?
I see that.
Yes. Minister Peters herself attempted to stop the investigations. This is the investigations being conducted by Werksmans, and in support of that allegation, he annexes a letter you wrote to him. Now, that letter is at page 154. I want us just to briefly look at that letter. Please go to page 154. This letter is dated the 12th of August, and I'm just going to read to you just so that we can expedite this process, Ms. Peters. You say, as a shareholder, I hereby write to express my concern over the long and protracted investigation by Werksmans attorneys into several irregularities identified in the AG's report and the ever-rising costs thereof. Then in paragraph 2, you say, the situation, this is in the middle of the paragraph, oh, sorry, let me just read this first part. Whilst your efforts to clean up the organization and enhance good corporate governance are commendable, I'm deeply concerned that this investigation seems endless and without a clear scope with a specific end objective. And you say the situation has resulted in excessive spending, which is reported to be in the region of 80 million rand. Right in the last paragraph, then you say, I therefore ask that you close off this investigation process and consider the results or report thereof. Furthermore, the board is required to submit a detailed report indicating the progress and the outcome of the investigation. And then you say a determination of any further investigation and a way forward will subsequently be made after studying the report in detail. You confirm you wrote this letter?
I confirm, Chair.
Okay. I want you to please look at your affidavit now. Your affidavit appears at bundle L, and it is SS22. And I want you to look at page 13 on the left-hand side. Yes, paragraph 10.2. I'm just going to read off to you, or read what you say there. Where I refer to closing of, this is in response to now Mr. Molefe's allegation that you asked them to close off stop the investigation. You say, where I refer to closing off the investigation, I did not suggest that it be stopped immediately. I predicated it upon receipt of a report first, which had to be considered, and then later a way forward be determined thereafter, which is a far cry from terminating it with impunity at the instance of those who might have been fingered in that report. My letter is self-explanatory. And now you're referring to this letter that I've just read. Well, Ms. Peters, I do not want to debate this with you. But your paragraph, the last paragraph, is quite clear. Close off this report. If there is anything to be done thereafter, it will be done after we've considered that report. I'm just saying to you that that's what a proper reading of your, the last paragraph of your letter is. I'm putting that to you.
The purpose is for you to, if you don't agree with his understanding of your letter, to indicate that you don't agree and to indicate why you don't agree.
Chairperson, thank you very much for that assistance. I don't agree with the view that the evidence leader is placing before this meeting. It might be a wrong choice of words, but Mr. Molefe knows, because prior to writing this letter, we had an engagement.
So you don't agree? Okay,
It was not close off.
Chairperson, with respect, it's a matter of interpretation.
Yeah, okay.
I do not want to debate the matter for two reasons. One is time is of the essence, but the other is it will be an ongoing issue. I submit that the words here are quite clear.
Yes, no, but, well, I don't know, you indicated that there was a discussion between yourself and Ms. Peters, I assume with her counsel. What kind of time you had in mind?
It's
you want?
quarter to, we agreed that we would finish by quarter to 12.
Quarter to 12?
Yes.
Okay, all right. Well, it's an important aspect,
As you
and I don't want her not to appreciate the significance. So taking a few minutes on it might be justified.
Chair, just to be, good morning, Chair. Just
Good
to
morning.
offer assistance to the Commission, and I hope Chair doesn't mind addressing while I'm sitting.
No,
because
that's
I'm
fine,
using
yes.
this mic.
That's fine.
So thank you, Chair. I think I'm acutely aware of the importance thereof, and we should not rush it along on account of my own commitments. I will make a contingency plan so that we
Okay.
deal with this matter sufficiently.
Yes.
And of course, anticipatedly, I was going to pick it up in reply. So
Yes.
my timelines
Yes.
not to be
Yes.
of concern to the Commission.
Yes.
And I'll make similar arrangements for moving
Yes.
my client's flight.
Okay, no,
Thank you.
that's fine. And if need be, if we don't finish, we can always arrange even for an evening session where she might not need to be here physically. We can do a video link and as well as counsel. So if it's fine, they can come here. If it's convenient not to come, those arrangements can be made.
Yes.
But it's just important that those important issues be dealt with properly.
Yes.
Okay, all right. But I understand why you were approaching it the way you were approaching it.
Chairperson, may I express my appreciation to my learned friend?
Yes, yes. Thank you.
Ms. Peters, can I just say, the first sentence reads, I therefore ask you to close off this investigation process and consider the results or report thereof. That's what it reads. Is that correct?
Yes, Chair.
Now, I don't want to look at it in isolation because the law requires us to see everything in context. You then go to indicate what is to happen. You say, furthermore, the board is requested to submit a detailed report indicating the progress and the outcome of the investigation. Now, I take it when you're talking about the investigation, you're talking about the Werksman's investigation. Is that correct? So you have two processes now.
I'm sorry. Please articulate your response, otherwise it won't go into the record. You were saying yes to his question.
Yes, Chair.
Okay, all right.
Thank you, Chairperson. Now, so you say close off the report and close off the investigation, give me a report. Then the next step was going to be a determination of any further investigation, and a way forward will subsequently be made after studying the report in detail.
Yes, Chair. Can I? Chairperson, you'd understand that this letter was written at the time where we have had a discussion and an engagement with Mr. Molefe and the Chief Procurement Officer with regard to the derailed report. Mr. Molefe was conscious of the fact that there was also the AG investigation. The Auditor General then said his part of the investigation would then be collapsed into the one that will be dealt with by the Office of the Chief Procurement Officer. He even then said, because the levels that is being investigated even go lower to the threshold that I, as the AG, was working on. Because according to the Public Protector report, the Office of the Chief Procurement Officer was supposed to do investigations, which is under National Treasury, with effect from 10 million and above. And for me, Chairperson, in dealing with that, and in the discussion that we have had with Mr. Molefe and the then Chief Procurement Officer, Mr. Brown, we had in my office, we had agreed on a consolidation of all these investigations. And this report, Chairperson, I'll give you an example, Chairperson, and unfortunately, I said to Advocate Soni earlier on that Lina Lakaki Dipuo and Kiabua, when given a chance to speak, I need to speak. Chairperson, with all these investigations, and also the wise words used by the late AG in terms of officials suffering lethargy in the investigation, because it would be the same ones that goes to this investigation, the same ones go to the Office of the Chief Procurement Officer, the same ones go to the AG's, we agreed. And therefore, it was important that there be a report with regard to this, because Werksman, and I want to indicate, the beginning of the work of Werksman, because it was almost like an emergency when these things came up in the reports in the public space, Mr. Molefe came to me and even said, I've identified a company, and I said, okay, it's fine. That's why even in Parliament, I reported about this investigation. But what Mr. Molefe was supposed to do was to go back to the board, regularize this appointment, and make sure that it is according to the prescripts of the law, because it was then found to be irregular by the AG's report. And that some of those things that happens informs you when you have to make a decision. And Chairperson,
remember that the questions.
The close of.
Hang on, yeah, that I wanted to go back to that, because that's the question of what is it that you can tell me that supports your interpretation.
Chairperson, closing of the report was, let's get, these people have been investigating. Do you have a report that says this is what we now found? So that if there is a need for continuing with the investigation, you then say, now follow. Because let me make an example, Chairperson. If you give terms of reference to an investigator, they would come to you and say, up to so far, this is what we found. But in the process of investigation, we found new evidence that says there is need for further investigation. And then you then go back and say, continue with this investigation, or you take a decision that says, this is a matter for the police, or this is a matter that we will deal. And it is that in that context that this particular issue was raised here. To say, can you conclude on this particular Werksman investigation? It was not budgeted for, it was unforeseen, and in the next year, because in the previous year it was unforeseen, Chairperson, in the next financial year, it cannot be unforeseen. It means you are already busy with the work. You either go to the board and say to the board, there is an investigation, let us continue with it, and there's a resolution of the board that says we will continue with this company. And for me, these were the things. And this matter was also one of the things that were flagged in a letter. No, it's not in a letter. In a report that I received from my PLO from Parliament, that there is a query raised about the irregularity of the appointment. And my issue was, If you close it, you get a report, you bring it, we then agree on the other parameters, because there was, I'm making a very good example to you, Chairperson, about some of these investigations we're involved in. I don't know why Mr. Molefe is also not raising them here, Chairperson.
Don't go that far. You have made, I think, the points you wanted to make, namely, you wanted to obtain a report. You were bearing in mind that the chief procurement officer was going to do certain investigations, and you are saying that after you had studied the report, a decision could be taken on the way forward. That's what you are saying.
Yes, Chairperson.
Okay, all right. Mr. Sonnen?
I'm going to say to you, Mr. Peters, that having regard to what the words you used say, it's not consistent with what you're trying to say this was implied. But I want to also say to you, and I want to say to the chairperson, for present purposes, it's irrelevant, because I want to suggest that what is contained in this letter must be seen against further developments that took place in this, as regards this issue. I want to then take you, and Chairperson, I just don't, there are times when everything rests on a particular issue, and there are times when they don't. I submit this is one of those. I want you to look at Mr. Molefe's reply now, which is PM 8 to the letter, which is at page 157 of Bundle D, SS6. Right, and you'll see there, he says, right at the top, I acknowledge receipt of your letter of 12. That's the same letter. But I want you to bear in mind one important factor, Ms. Peters. Look at the date of that letter. It's the 24th of August. Sorry, Ms. Peters, do you accept that the letter is dated the 24th of August?
Yes, Chair.
Right. Now, he refers to meetings, and then he tells you his response to what you've asked him to do. He complains that they can't comply with your request because they are obliged by the different provisions of the PFMA to continue those matters. But again, for present purposes, that's irrelevant, because at page 160, he talks about this meeting in regard to the Public Protector's report. You see, the reasons for the referral of the investigation as part of the implementation of the Worksman's report was a realization there were similarities between the two investigations. You see that?
Which
this
part?
Is at page 160.
Which part, Chairperson?
The first, where he says the Worksman's attorneys is the investigation part of the remedial action by the Public Protector. Right at the top. You see that?
I see that, Chairperson, but I don't think that that statement was correct, because Werksman had started even before the release. The work of Werksman was increased by the release of the Public Protector report.
Can I just ask this question? And it goes back to the question that about what meaning one should attach to your letter, where you say the Werkman's investigation should be closed off. You can't hear me well?
I couldn't hear you well.
Oh,
Chair.
is that so? You must just tell me, then I can raise my voice. One of the points you made earlier on was that you wanted Werkmans to submit a report that report would be studied. And thereafter, the way forward would be decided upon. Is that right?
Yes, Chair.
That's what you said. Now, I see that the last sentence of Mr. Mulefe's response to your letter, his response being the letter that starts at page 157, he does say, the minister directs us to close off the investigation and submit a detailed report to your office so that the minister can make a determination as to whether there is a need for a further investigation. It's the last sentence at page 157 that is in the Mr. Mulefe's letter response to you. That is in bundle D, exhibit SS6. So, but that's the letter that Mr. Soni referred you to. Have you got it? The bundle that has got Mr. Mulefe's affidavit. If you go to page 157 on that bundle, the red numbers this time, not the black numbers. Can you see the letter?
Can the board, the chairperson come again? I'm struggling to follow because your voice is a bit low.
Oh, okay. You see, I'm used to people saying my voice is too loud. So, so it's not often that I'm accused of having a voice that is soft. Okay, you remember Mr. Soni read your letter to Mr. Mulefe. You remember your letter?
Yes, Chair.
And thereafter, he referred you to Mr. Mulefe's response to your letter. You remember that?
Yes, Chair.
That's the letter I'm talking about. Have you got it? It appears at page 157.
Yes.
You have got the letter.
Yes, Chair.
Okay. If you go to the last sentence of page 157, which is the first page of that letter, that's the sentence I'm talking about. And I read it again. The minister directs us to close off the investigation and submit a detailed report to your office so that the minister can make a determination as to whether there is a need for further investigation. You see that sentence? You see the sentence, that's what I want to know at this stage.
I see that sentence, Chairperson, like I indicated that this
No, don't indicate anything. I just wanted you to first
Oh,
see
I see the sentence.
Yeah.
I see the sentence.
So I'm saying to you, it would appear that Mr. Mulefe's understanding of your letter was, at least in this respect, the same as yours. Namely, that after the report, after Verkman's report had been studied, there would be a determination of the way forward. And as he understood your letter, the determination of the way forward would be whether there was a need for further investigation. So I'm simply saying this sentence may well support part of what you were saying. You understand?
I understand, Chairperson.
Yes. But Mr. Soni will see how he deals with that. It suggests to me that it was not necessarily contemplated in your letter that there would be no further investigation.
Yes, Chair.
But as to who would do such an investigation, if there was to be an investigation, that was something to be dealt with later.
Yes, Chair.
That's the impression I get. But also, what is clear from your letter to Mr. Mulefe is that you were not saying, let Verkmans stop for now. Give us a report, and then we'll take it from there.
Yes, Chair.
You don't put it that way.
Yes.
Don't say, let them suspend their investigation for now until we have studied their report.
Yes, Chair.
You are saying to the board, close off this investigation. And then, of course, you say the other things as well. So I'm just mentioning this to, one, share with you my understanding of what this seems to say, but to also enable Mr. Soni to deal with the various fissures that I'm raising.
Okay, Chair.
Okay, all right.
That is what your letter said, that in fact, there were three things that were to happen. The investigation, there must be an investigation report from Werksmans. That report, the board must send you their report on the Werksmans report,
Yes.
and then a determination will be made. That is what your letter said. Is that correct?
Yes, Chair.
Right. Now, what though is important is, and the chairperson is right, that it was not going to be the end of the matter forever. Everything would depend on the developments. Would that be correct?
Yes, Chair.
Right. Okay. Now, there are two things, though, about the letter, and I said to you, in a sense, whatever interpretation one places on that is for present purposes not decisive. Now, as part of this letter, yesterday I read to you the issue at page 163, which was the issue of the permanent CEO. I'm just saying that it's part of the same letter. I want to refer you to something else. He says to you at page 160 in the last paragraph, page 160 in the last paragraph, he says that litigation has flowed from this investigation and it involves a lot of money, and he says that one of the problems that has arisen is the very people against whom PRASA was litigating was seeking funds from PRASA to fund their fight or their litigation fight against PRASA. You see that? For example, one of the companies he mentions is Siangena. Do you see that, Ms.?
Yes, I see it in the second
Yes.
paragraph on this page.
Yes. Now, what he is saying in the letter is that there are serious matters that arise from this, and we can't stop the investigations. That's what he is effectively saying. Would that be correct? That's how you understood it. Now, I want you then to look at page 161. In the middle, right at the top, he says, Werksmans have advised the board that as a result of their investigations, the board is obliged to report the matter to the police or to the crime or the DPCI in terms of the Prevention and Combating of Corrupt Activities Act. That's what he says there, right? Then he says that PRASA is funding their forensic investigation. But we'll deal with that at a different time in these proceedings. But I want to look at the last sentence of that. He then says to you, before the last sentence, he says, they've asked the DPCI for assistance. Says, I am not aware of any instance where DPCI have begun taking statements or any other investigative action of significance. You recall reading this in Mr. Molefe's letter?
Yes, Chair.
Then he says to you, I therefore implore the Honourable Minister to intercede on PRASA's behalf with the Minister of Safety and Security to expedite these matters which are of national importance. You saw that?
Yes, sir.
Who was the national minister? Who was the Minister of Safety and Security at the time?
I'm not sure whether it was still Minister Nati Ntleko. I'll have to recollect.
Okay.
But it was either Minister Nati Ntleko, but it was not Minister Mbalul.
Did you approach the minister?
I did approach the minister, and you see, Chairperson, here it indicates that we should engage the minister to expedite these matters which were under now the DPCI. The minister at that time, in fact, to his credit, we were discussing it as we were seated in the House. So it was not a formal meeting. I indicated to him that there is this particular request from PRASA. And at that time, it was not only PRASA, there were matters of the RTMC and many others. And I said to him, if need be, we could have a meeting so that we have a full presentation. And he even said, you know, with regard to matters that have been referred to the police, there would sometimes be an impression created that we politically influenced some of these things. So we at the end, we had not had a meeting formally with the minister with regard to these particular matters.
So I'm trying to understand your answer and tell me if I'm wrong. Mr. Molefe asks you to intercede because there's no progress in these important investigations which involve perhaps billions of rands. You talk informally to the minister, whoever it was, but you don't formally raise with him the concern that Mr. Molefe raised with you.
We had not as yet arrived at the point where here we are in cabinet. I have this particular letter, and I say to the minister, there is a meeting I request that we have with regard to matters that pertains to the matters referred to the police and all that. And he then said, no, we will make the arrangement for a formal meeting, but I just want to indicate to you, at times as a minister, he said, I'm wary to involve in matters that are already under investigation because then it will be misconstrued as political interference. Then we started the process to request for a meeting with the minister. I just want to respond to one aspect, Chairperson. I'm sorry not to look at you and address you with regard to that particular matter. In this response of the 24th of August to my letter of the 12th of August, Chairperson, this summary of the report, if I had received it prior, I would not have written this particular letter. I just wanted to put that on record. Because...
I'm sorry, just start afresh. If you had received...
this response on what has happened since they have employed Bergsman.
Yes.
Because, Chairperson, at the time that the Bergsman was...
Yes, hang on, but I wanted to complete the sentence. You completed it earlier on. If you had received this, you would not have...
Because this is a report.
Yes.
On where exactly they are with the process of the investigation.
Yes.
Because there was a lull.
Yeah.
And there would not have been a need for saying close off the report because the report is reflected here on exactly where they are. But also, Chairperson, in the report, it does indicate that there has since been, you know, in most investigations in my areas of deployment, I've realized that investigations moves in a loop. Once you open it, it becomes, when the loop is supposed to close, new evidence and new information come in, and then investigators go on. So You need to be able to make sure at different intervals, you engage with these investigations. Every time in Parliament, ministers are asked questions about these matters. And if you are not conversant with what is happening, you won't know. At that particular time, Chairperson, there was already a decision that we had made with the chairperson of the board, as well as the OCP, the Office of the Chief Procurement Officer, that there is going to be a consolidation on these investigations. So in essence, we were now at the stage where we're supposed to now start getting reports from the Chief Procurement Officer that says, with regard to all these matters, this is where exactly we are.
Just to make sure I have understood your evidence. So you are saying, when you look at Mr. Molefe's response to your letter, and you look at the content, what he says about progress that had been made, had you been aware of this progress at the time you wrote the letter to him which said close off the investigation, you would not have said the investigation should be closed off? That's what you are saying?
Yes, Chairperson, because I would have had progress reports.
Okay, all right. Mr. Soni?
Chair, might I just interject? Firstly, Chair, I'm going to seek guidance from the Chair purely to be of assistance to the proceedings.
Yes.
And this is where I come from, and Chair will correct me if I am wrong.
Yes.
I'm acutely aware that these proceedings are sui generis. And holding a watching brief over Ms. Peters comes with some constraints.
Yes.
On my part, because I want the proceedings to flow.
To go smoothly.
And I am not one to interject every now and then as if we are in adversarial proceedings.
Yes.
These are inquisitorial. The evidence leader is supposed to unearth facts,
Yes.
good or bad, against the witness. And that is why I've kept mum on a number of issues. Now, the clarity that the Chair has now elicited from Ms. Peters is what would have prompted me to say, but hang on, don't put a witness in a position where she may be misunderstood because you are drawing correlations. We started off with the conclusion and the interpretation that my learned brother sought to put on a conclusion. And as we were dealing with that, he started gravitating to the letter of the 24th of Mr. Molefe. And the point that I wanted to make, or that I would have made, was if we are going to put a submission to a witness to say, I submit or I put it to you that this is the interpretation, one tends to enter into a legal terrain with a non-legal witness. Let the hawk alight where the eagles perch, because if you look at that letter, the very opening salvo talks about what animated her concerns. Her concerns were an irregularity that had been flagged and the exorbitant amount of money that may have been paid at the time. So she's following through. So I left it at that because I thought it may well be that when we make submissions, we'll have a look at it. And the Chair then summarized it in a manner that the witness said, I agree with your interpretation, Chair. And even with this letter of the 24th, it is clear because we have read the affidavits, but the person watching these proceedings from home doesn't understand. And it is because of the Chair's intervention that she was able to say, actually, the letter of the 24th is a sequel to mine of the 22nd. So, if I had received a summary of the progress report, which I do now 2 days later, it would have been nonsensical for me to write a letter about whose interpretation we're quibbling. And I'm simply trying to say, if, Chair, I am right in saying I have the right to come back, not necessarily a la re-examination, but where a witness can give clarity to Chair at the time. Let it happen so that we don't interrupt the flow. Otherwise, if I leave it too late, it may well be that an opportunity may be squandered for the commission, not for me, not for the witness to understand. So I'm placing my dilemma on record. Ordinarily, if we were in a criminal trial, I would have been up on my feet and raising up, and that's not my style.
No. I understand. I think that my understanding of how you represent your clients gives me comfort that if you were to ask for an opportunity to interrupt, it would really because it's something quite serious. My understanding, you are not appearing for the first time. Yeah. My understanding is that you are very constructive. You want the commission's proceeding to go smoothly, but obviously you are looking after your client's interests in the process. So I would say, as far as possible, keep your notes because I'll give you a chance to re-examine. And during that time, obviously, where you think she might have given an answer that was based on a misunderstanding of the question, there can be clarification. I accept that there may be situations where it's necessary to come in and not wait for later, but I think those would be rare. So I'm sure that we can handle the situation.
And Chair, in so saying, I was not suggesting in any form or shape that Mr. Soni was being unfair to the witness.
Yes,
I think as lawyers, we know where we're going with the full
Yes.
import, but non-lawyers may be faced unnecessarily. But
Yes.
it's really, Chair, I'll leave it at that.
Okay, no, that's fine. Thank you. Mr. Soni?
And again, it's not a reflection on my learned friend or the witness. I've read the response of the witness's affidavit to what Mr. Molefe said. She was given the whole affidavit, including Annexures 7 and 8. She responded to Annexure 7 in 10.2, which is what I had read to her, which is why the issue had arisen. And she, in her affidavit, said, but look, I'm sorry, had I received Annexure PM8, I wouldn't have even written Annexure PM7. So you must read Annexure PM7 together with PM8. But that's what she has said today. But that's not what she said in her affidavit, which is why the questioning took place.
Yes, no, I think I'm satisfied that we can go on. Mr. Majava has a full understanding, and he will be noting areas that might need clarification for later. Yeah.
Absolutely, and he must be entitled to that.
Yes, no, that's fine.
Now-
Thank you.
Ms. Peters, this is what I want to ask you next. Did you respond to Mr. Molefe's letter? I mean, you've told the court, you've told the commission today that, look, had I received or had what is set out in this letter been sent to me, I would have understood what it is. I wouldn't have asked for a report. Did you respond to this letter from Mr. Molefe, the letter of the 24th of August?
Chairperson, I don't remember fully whether I ever responded to that letter, except to say that there was a meeting sometime thereafter. So I don't know whether I responded in writing.
Okay, because I'll tell you why I ask this. If you look at that letter in the very last paragraph of the letter at page 166, Mr. Molefe says, having set out what the position of the board is, he says, I trust that this clarifies the board's stance in this regard. We shall, in correspondence to follow by the end of August, provide you with a detailed report of the forensic investigation undertaken by Werksman's attorneys on the board's instructions. Now, two questions arise. Did you receive such a report from the board?
I don't remember receiving it because at that time we were preparing already towards the AGM of the company. So I would need to go back and find out. I don't remember, Chairperson.
But I also understood you to say that you had talked. And is it possible in that talk you had said to him, but don't worry about the letter, the report, because what you've said to me satisfies me that these investigations should continue. I'm just asking because you've not complained about the fact that there was no report.
Chairperson, in talking to Mr. Molefe, the only thing that I said to him is, when are you going to make sure that this issue of the appointment of Werksman get regularized? Because we're going now into the third or fourth year of this, it was actually the third year of this investigation. And in terms of the PFMA, it cannot be at all times unforeseen and unplanned, Chairperson. And my concern was, can the board regularize this? Don't create an avenue where again it becomes an audit finding. Because that was the issue, Chairperson, that this investigation, okay, now we've got this report that you promised that by the end of August, you will present to me. Because he then said they're going to do a consolidated report, they will present the report. But I then said, over and above the consolidated report, I'm speaking to a comrade Popol Molefe, a leader in this environment, to say, get your board to regularize this appointment so that you don't end up again. Chairperson, no two wrongs make a right. You are chasing, and I'll make an example, you are chasing, like he used to say, I'm chasing the thieves. I say you are chasing the thieves, but you go chasing the thieves in a wrong way, where you end up being found at fault for violating the procedures. I even said to him, Kaswana, Naliana, we could speak Kaswana. Ntate Molefe, how fitla o itlela ntlo ya gago e sha? If you find your house burning down, you see that Dipuo is responsible for burning down your house. You know it's Dipuo. Do you now chase Dipuo instead of putting down the fire and then get the relevant agencies to chase Dipuo, because you have seen Dipuo has burned down your house? And I was saying to him in an idiomatic expression to say, let's focus on the key other issues that are related to PRASA as a company, which are related to the performance of the company, the trains, the finances, and all those. Whilst the investigation is ongoing, in my mind, I was satisfied with the meeting that we had held in my office, where there was a clear indication that we are going to consolidate all this investigation. And in fact, we did acknowledge that these investigations have got a tendency of running for years. And now that they are under National Treasury, you would not even have the fear of the budgets and all those, because it would have to be in their budget to be able to do that work. And in that way, and it's taking me back to advice that I once got from one of our leaders who passed away, Ambassador Maseko. He used to say, in that time he was an ambassador in Namibia, that one thing, and he was giving me a good advice as a leader and a father. Because in the way in which you do your work, do it in such a nature that you don't have challenges later because of either, in fact, he told me that because o utswitse or eng. He said, if it is a matter of not doing your work because of some limitations of training, whatever, you can be trained. Mara utswa, how now train you are better than gore o utswitse. So in my doing of my work,
Just remember to give us a translation as well, because otherwise
Yes.
not all your points will be understood by everybody.
I had this advice from a leader, and the advice from this leader was to the effect that in the way in which you do your work, you must do it effectively, you must do it to the best of your ability. But one of the challenges of working in a government environment, he said, is that rather be found at fault for for your inability to do some work as opposed to being being a thief, for a lack of a better word. And I always carried that in the back of my mind, because I knew, because he said it clearly that a thief cannot be trained differently. But if you have got limitations in terms of the ability to do it, you can be trained, you can be reskilled. And if it was wrong for me not to write to Mr. Pope Molefe in terms of this letter that he had written that showed that they do have a report. Remember in his affidavit, he says they were going to, at the end of that month of August, present me with a consolidated report with regard to this Vexman's report. A report that had been waiting for, and I want to put it on record. In the beginning, when the investigation was what is this? Vexman started, there were a lot of issues that needed to be investigated in PRASA. I agreed with Ntate Molefe to say there are those things that truly need the organization to follow, which is those that bought 350, the payments and the advance payments, because there were allegations from the AG's report that service providers were paid to be able to do work. So they get paid before they do work. It is wrong. Those are things that create the irregular. And then, Chairperson, there was also investigations. One of the things that were cited in this report of the AG was the issue related to the rolling stock and to the signalings and whatever. And I said to Ntate Molefe, me and you growing up in South Africa, knowing the challenges, Chairperson, of the passenger rail system, and knowing that our people rely on this system, you know that we have to save, especially the new trains.
Okay.
It's just that this platform doesn't give one chance to explain some of even the challenges
Yes.
ones had to experience.
Yes, but I think what emerges from your answer is either that you did not respond in writing to Mr. Pope Molefe's letter, or you can't remember whether you did respond, but you say that there was a meeting that the two of you had after his response to your letter. Yeah, that much you say, Mr. Soni.
Now, you might recall that I said to you, Mr. Molefe's letter is dated the 24th of August 2016. On the 25th of August 2016, Mr. Molefe made an affidavit which had major repercussions for his standing in the ANC, certainly according to what appears to have happened in Parliament. I want to ask
Come
you,
again.
well, I'm saying to you, on the 25th of August, Mr. Molefe made an affidavit in the Swifambo matter, which, according to what appears to have happened in Parliament, had a major impact on the parliamentarians, the ANC parliamentarians' approach to him. I'm going to come to that in a moment. But I want to first deal with the allegations he made on the 25th of August 2016. They are contained in his replying affidavit, parts of which appear at page 259 of Bundle D.
What is the page number?
259, Chairperson. That's the first page. And then, of course, the allegation appears
259 of?
259 of Bundle D. That's Mr. Molefe's replying affidavit. Now, I don't want to go through the whole thing, but this is a replying affidavit in the Swifambo matter. That is the 3.5 billion rand contract that we talked about yesterday. Now, this is what he says. If you go to page 262, he talks about what he was told by a Mr. Oswald Mashaba. Says Mr. Mashaba told us.
I'm sorry, Mr. I'm sorry,
Page 262.
Mr. Soni. What I have at page 259 is the first page of Mr. Molefe's replying affidavit,
sorry.
but the next page relates to Mr. Mamabolo's affidavit. I don't have other pages of Mr. Molefe's affidavit that starts at page 259. So from 259, my bundle skips to 277. I don't know whether I may have taken out the affidavit myself to read it and then did not
I'm
replace
sure
it.
what somebody did, and I'll tell you why, Chairperson.
Yeah.
When Mr. Molefe gave affidavit, we went, evidence,
Yes.
we went through this affidavit.
Yes. Is there a spare one
Yes,
by any chance?
Mr.
And then
Chairman.
arrangements can just be made for replacement pages. I see that we have gone past 11:15, but since Ms. Peters has to leave by 2:45, I thought we would take the tea break a little later
Yes, as you please.
so that she can leave, and then arrangements would be made for when we can continue. Okay, all right. Thank you. So you said we must go to page 261, yes?
262, Chairperson.
262,
Yes.
okay. Yes.
So he says that Mr. Mashaba told him that he was aware that the Swifambo tender was under investigation. And then on the next page, he says Mr. Mashaba told him in addition that through his involvement, that's Mr. Mashaba's involved with Mr. Mabunda, he had been in contact with a Maria Gomez, who had initially contacted him telephonically. Then Mr. Molefe says, Mr. Mashaba explained that he met with Ms. Gomez. Ms. Gomez told him, that's Mr. Mashaba, that she wanted money for the movement. Ms. Gomez also told him that she knew the bid to supply locomotives to PRASA was worth billions, and she could not understand why 10% of the value of the bid could not be paid to the African National Congress. Ms. Gomez was insistent that the money should go to the movement. In paragraph 9.11, Mr. Mashaba explained further that Mr. Mabunda had instructed him to pay some of the money received from PRASA into specific accounts without Mr. Mashaba knowing who was being paid or the reason for the payment. Mr. Mashaba was insistent that he did not know the identity of the beneficiaries, and he was merely informed that the money would be of benefit for the union, for the movement. Now, when did you become first become aware of these allegations?
I became aware of these allegations through the press. It was in the public space, based on the submission of Mr. Molefe to the court.
Now, what was your reaction to this?
I asked him, Mr. Molefe, about this, and then he explained that there was this matter, and then he's following up with the investigation, and we left it as such.
Is that the total reaction?
Not the discussions between him and Mashaba, just that there was Shifambo and there was allegations that certain amount of money from Shifambo flew back into the African National Congress. That's what I read.
Were you concerned about, firstly, the allegations being made?
I was concerned, definitely, Chairperson, and I think there was even an interview that I did with the Sunday Times newspaper after I had also called on Mr. Molefe to verify the stories in the papers, and he confirmed to me that that is part of the investigation and it is going to help PRASA to recoup the money. And Chairperson, earlier on when you stopped me, I was coming to these 2 points about this investigation, the one of Shifambo and the one of the new modernization trains, to say...
Siangena.
No, not Siangena.
Oh, the Gibela
Siangena
one,
is the signaling and other things. There was this issue of, there was a finding related to the trains that to be built.
Yes.
And I said to him, they must ensure that they urgently deal with these matters, respond to it so that they can release. Remember, Chairperson, there was going to be about 53 billion rand investment into the country for the new trains, the factory to be built, to do the supplying components, but also the training of our young people with technology, techniques and skills that are necessary for the rail industry. So it was a massive investment that I said to him, we need to make sure that this one is dealt with so that the work can start. Our people are unemployed at the factory in Danata. We need to make sure that that one is unfolded. We agreed. And then these others, like Bo Shifambo and Siangena and the others that you are investigating, go ahead and investigate those particular matters. There was never a time where we did not agree on the need for investigating these particular issues. When the story about the money that flew to the ANC came, it was not a discussion. It was what was submitted in the court papers. And I even said, now that this matter is an investigation, and I said, and I'm still believing it. What I said to that journalist here, Sunday Times, was that if I was the Treasurer General of the African National Congress, I would also, on the side of the investigation of government and its entity, with regard to this procurement, investigate these people who are said to have received money in the name of the African National Congress. Because for me, as a member of the ANC, it was not good that people go around doing whatever they do, and later on it is said that the money flew to the ANC. So the 3G had to investigate that. Whether he investigated, I don't know, because I made a public statement that was in the Sunday Times to say, I say, go ahead and investigate on your side also as the ANC. Because if there are people who are going around making money for themselves and their families in the name of the ANC, it's also incorrect, because the name of the ANC is always brought into these procurements, and unnecessarily so, because certain people will do wrong things and then say, I did it for the ANC, which is not true.
Now,
Mr. Soni, I propose that we should stop with Ms. Peters' evidence at past, which is 5 minutes' time.
Yes.
Then I take the tea break, then she's released.
Yes.
I know she's available up to 1:45, but we take the tea break at half past, because in any event, we are not going to finish with her evidence. So I'm just mentioning so that in terms of what is left.
What is left?
Yes.
Can I, Chairperson, it may take a couple more minutes than 5. Is that going to be okay?
That's fine.
Ms. Peters, can I then ask you to look at parliamentary bundle 3, page 382 on the left-hand side?
I take a couple of minutes, more than 5 minutes, but not 10.
Okay, I'll try and make it 8.
Yeah,
Yeah.
I'm thinking about 7 or so.
Yes.
Parliamentary bundle?
Bundle 3, page 382.
Page?
382.
$382.
So, remember, Mr. Molefe's affidavit is dated the 26th of August. As you've said, it was widely reported in the newspapers. Now, on the 31st of August 2016, this matter came up before the Portfolio Committee. And this is what Mr. De Vries says about it. He says, at the meeting held on the 31st of August, this is of the Portfolio Committee, the acting CEO, Mr. Collins Letswalo, explained that PRASA had a dysfunctional administrative system. He explained that only 20 executives were required as opposed to the current 65. He claimed it appeared that PRASA board members were paying themselves additional unauthorized remuneration. Mr. Sibanda expressed concern that the board members were paying themselves. Now, I just want to deal with the first issue first. The one about 20 executives as opposed to 65. Had you been made aware of that before Mr. Letswalo raised it in Parliament?
This matter, Chair, like I've indicated, was going to probably be the subject of the meeting of the AGM, because the AGM was coming. We were working towards the AGM. I had not as yet received a report with regard to these details. But one thing that I knew from the history of engagement with PRASA was that it had a bloated structure, and the executives would be just moved willy-nilly from across, irrespective of their competencies and whatever. And I had requested the board, remember, Chairperson, I indicated yesterday that I had requested the board to do a skills and competency and qualifications audit so that they could then do a better matching and placing within the organization, because there were just too many people who you didn't know what they were doing, and others were all over. And there were a lot of labor-related disputes of others who were dismissed, and the board chairperson at times took a decision to say some of those who were dismissed must just be brought back, and it would have needed a particular review or an organizational design type of study to be able to get to that particular point. Then
The next point that Mr. De Vries makes in this summary, he says Mr. Ramatlakane stated that recently there had been an extraordinary board meeting where a resolution had been taken to dismiss Mr. Letswalo. He requested PRASA and the chairperson to appraise the portfolio committee developments in this regard, and that the portfolio committee receive a copy of the board minutes. Now, this is Mr. De Vries' comment on this. I got the distinct impression that this had been discussed by the ANC, and it was there was an agenda to of sorts to protect Mr. Letswalo. You were not present at this meeting, is that correct?
No, Chair, I was not at the meeting.
All right. Then Mr. Molefe asks the meeting if they could discuss the matter in committee, and that was refused. Now, I'm raising all of this in the context of what I read to you in Mr. Molefe's affidavit, because if you look at the next page, page 383, on the fourth paragraph, this is what is reported. Mr. Mashwangani stated that Popo Molefe had insinuated that the ANC had received 80 million rand from PRASA, and then he says this was a reference to articles that had been appearing in newspapers, and he gives the whole this thing. Then he says, Molefe denied he had made such a statement, stating that he had heard allegations that PRASA had paid the ANC 80 million rand. He explained that PRASA never paid the ANC money, and he had never made such claims. He indicated what the media had reported were records before the court. Then, this is the response from Mr. Mashwangani. He says, he had a concern that PRASA spent 93 million rand on private legal firm for services. This is Mr. De Freitas' comment. This was the ANC's attempt at deflecting from the true issue of corruption by deflecting from the real problem. It was very clear that the ANC was positioning Molefe as the enemy or the bad guy in this saga. Now, this is a commentator who is in Parliament. Of course, he's in the opposition, and one would expect him to say things that don't reflect well on the ANC. But when you look at the two things that appear here, the first thing is that there is the story about corruption relating to this Wafambo contract, from which a political party allegedly received 80 million rand. And then 93 million rand is spent in investigations. Now, does it make sense that you would concentrate on the cost of the investigations as opposed to allegations of corruption in a 3.5 billion rand contract?
Chairperson, I can't answer for the portfolio committee because I don't know the context of them arriving at this point, because usually what happens is that the department and the board would come and make their presentations, and then the questions and statements would flow from that. So I was not there, and I cannot make a case for what happened in the portfolio committee.
Okay. I just want to read to you, though, the second last line on that page.
It has gone to 10 minutes.
Yeah.
Can I just finish this, Chairperson?
Okay.
And I undertake it'll be the last point I want to make.
Okay.
Mr. Khadebe, the ANC member on the committee, suggested that the committee had to approach the South African Police Service to investigate Werksman's political and business links. I'm putting this in context, and I know you are right, you can't answer for it. I'm only making the point that that is what the fallout was from what Mr. Molefe disclosed and what Werksman's investigations had revealed. As you said, it was probably procedurally flawed, but there are two issues here. You agree with that?
Chairperson, once more, I'm unable to relate to what Honorable Honorable De Freitas is referring to here with regard to the matters in the committee. Usually, after the committee, the committee report would be tabled in Parliament. And what would be tabled in Parliament would be the decisions that the committee has made, not the debates in the committee. So, Chairperson, this is a reflection on the debates in the committee, and like I indicated, I was not probably part of that particular meeting.
Okay.
Chairperson, we'll have to stop here.
Yeah, we'll have to stop here. Arrangements will be made for the commission to hear the balance of your evidence, Ms. Peters. And everything will be done to try and make sure that that happens as soon as possible. And if there is a need to have your evidence via a video link or Zoom in order to expedite that can be done. So we'll stop here. Thank you very much, and thank you to Mr. Majava.
Mr. Majavu,
Majavu, I'm sorry.
thank you,
I
Chair.
think it's the second time,
Actually, the third time.
the third time. And I haven't done that before, it's just today. Yeah, okay, we'll stop here. Thank you very much, Ms. Peters. There was one question I wanted to ask just for clarity, because I saw in some newspapers this morning, they seem to portray your evidence in a manner that I thought was not correct, but maybe let me ask. With regard to Mr. Mulefe's evidence that at the meeting of the 20th of August, I think he says truth. One of the things that he says is that President Zuma said Mr. Montana's talent should not be lost to the country. That's one. And two, he says he got the impression, or it was clear to him, he says one of the two, that Mr. Zuma wanted Mr. Montana to be taken back at PRASA. Your evidence with regard to the statement that Mr. Zuma said Mr. Montana's talent should not be lost to the country, what do you say? Do you remember it? Do you not remember it? Do you say it never happened?
Chairperson, you'd remember that I indicated that at the time the board in Chairperson came to inform me of the fact that Mr. Montana's contract will be coming to an end and what they had discussed with him. In fact, even him, Mr. Mulefe, was of the same mind with me at the time that this is something that we need to deliberate on, about how do we as a country, not PRASA, utilize the knowledge, institutional memory, and the expertise.
But remember, because you have to catch your flight.
Yes,
The
Mr.
question is whether your recollection...
I went to President Zuma and said to him that there are 4 CEOs whose contracts are about to end. And I said, they started with transport from 1994. We can't lose them, Chairperson.
I remember that. All I need is whether you have a recollection that Mr. Zuma did say that at the meeting, or you have no recollection, or you say he did not say it at the meeting.
At the meeting, I don't remember what President Zuma had said. That's why, Chairperson, yesterday I said, there is a possibility that in their informal these things, it might have been raised. But at the meeting, the president actually got exhausted before the meeting finalized. So he could not conclude that meeting.
Okay, all right. Now, of course, when I was putting certain questions to you yesterday, you did say, and you must tell me if I misunderstood you, that you understood the proposition that President Zuma must have said something that made Mr. Molefe invite him to come to the board and address it so as to understand the rationale of the board's decision not to, or to release Mr. Montana. I think you said you can understand the logic that he must have said something. Is that correct?
Yes, Chairperson, but also knowing that
Yes.
Mr. Montana was lobbying. And I want to just put it on record here.
Yes.
That probably Mr. Montana's attitude towards me is based on the fact that when he lobbied me, I said it's a no-go.
Yes, yes, yes. And I think I did say yesterday, make the proposition that on the face of it, it seems that, it seems logical that Mr. Zuma must have said something that suggested that he didn't understand the rationale of the board's decision to release Mr. Montana. You had no quarrel with that. Is that right?
Chairperson, the
Otherwise,
only
why-
thing that
why
I
would
fully
you
remember,
want to-
Mr. Zuma said Mr. Molefe and Mr. Montana and myself are all ANC members. Nilwelani.
Why are you fighting?
Why are you fighting?
Okay, all right. I will release you now. I will take the tea break, and we will resume at 12 o'clock. And then we'll start with the next witness. You are excused.
Chair
You are
Matai
excused, Mr.
also know
you
that
are
I'm
also
excused.
Yes, thank you.
Thank you, Chair.
We adjourn.
Thank you.
Are you ready? Just put on your mic. Yeah. Okay.
Thank you, Chairperson. Chairperson, the next issue we are going to deal with is the matters raised about the appointment of worksmen to do the investigation. And as you would have realized, it's something that has appeared on and off our radar screen from the time Mr. Molefe first gave evidence.
Yes.
What we intend doing, Chairperson, is Mr. Ngoyi has prepared a report with the chairperson of the new board, which is a fairly recent report, prepared at the end of last year. And she has made that report available to us, and she will talk to that report, which sets out all the facts, certainly as presented by her. We have then Ms. Manasseh, an affidavit from Ms. Manasseh, and we have an affidavit from Mr. Hotz from Berksmans. And effectively, as you said yesterday, Chairperson, the facts, the essential facts are not in dispute. There may be issues here and there where there's a difference, but the question really would be, have the provisions of Section 217 been complied?
Just repeat that. The question would be?
Have the provisions of Section 217 been complied with?
Yes.
Is 217(1) of the Constitution?
Yes. Well, to the extent that that's the question, really one doesn't need to spend a lot of time on the issue.
Yes.
Because once the facts are undisputed, it's a question of applying the law to the facts and giving an answer to that question.
Yes.
If there is no suggestion by anybody that to the extent that there might not have been compliance with Section 217 and whatever other provisions of the law, if there is nobody who suggests that that non-compliance was deliberate,
Yes.
in the sense that somebody knew it was wrong and did it for some ulterior
Yes.
motive, then really one doesn't need to spend too much time on the issue.
Absolutely, Chairperson.
Yeah.
Except, may I make this point, Chairperson, one of the reasons it is necessary to air this issue is...
No, I agree. No, I agree that it should be aired
Yes.
Publicly. It's just that there might be no need to spend too much time on
Absolutely.
it.
Absolutely.
Yeah.
Yes.
Okay, all right. Good morning, Ms. Ngoye.
Good morning, Chair.
You are back.
I'm back, Chair.
Okay, all right. Thank you for coming back.
Thank you, Chair.
Yes.
May the witness please.
Registrar, please administer the oath of affirmation.
Please state your full names for the record.
Monica Martha Ngoye.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath binding on your conscience?
Yes, I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Okay, you may proceed, Mr. Soni.
Thank you, Chairperson. Mr. Ngoyi, you've given evidence before this...
Maybe you can just announce for the record which bundle we are going to be using now.
Chairperson, there would be two bundles we will be looking at while Mr. Ngoyi is giving evidence.
Yeah.
E2, which is her affidavit in relation to this matter.
Yes.
And then there will be a reference to what Ms. Manasseh says in her affidavit and what Mr. Hotz says in his affidavit. And Those appear at bundle M, Chairperson.
Okay, all right.
Ms. Ngoyi, as the chairperson indicated, you have been here before. Is that correct?
It's correct, Chair.
And you've given evidence here before.
Yes, I have, Chair.
Now, I just want to place on record, because you've asked me to do this, that you, on the previous occasions you came, you dealt in general with matters relating to corruption at PRASA, the manner in which the former CEO, Mr. Montana, ran PRASA. But in particular, you dealt with the problems that were found with the appointment or the award of several contracts to Siangena with about 2.8 billion rand. Is that correct?
That's correct, Chair.
And of course, there were other matters like the CIA matters and so on. But well, let's leave that out for the time being. Today, you're being called on to deal with an entirely different matter, and that is the appointment of Werksmans to conduct the investigation. But before I go on, I understand you want to address the chair on something.
Chair, if I may, please, may I be given an opportunity to address you?
Yes.
In fact, I've put my thoughts in writing, Chair, so that I'm not all over the show. If you will also allow me, because it's quite emotive for me to go through this.
Yes, okay.
This is about, the mixed emotions, Chair, that I had coming back to the commission this time in light of what has transpired. And you will note in my affidavit, I do state that I am no longer employed at PRASA. And I just penned some notes down, Chair, so that I think it's important for us as whistleblowers to express this frustration that we have had to deal with. And with your permission, Chair, if I may please.
Yes, no, that's fine.
Read what I have written.
Yeah.
I start off by saying, from the inception of the commission, Chair, you made an impassioned call to people who are aware of instances of state capture to come to the commission to share their information with the commission. The people who will have direct evidence of state capture are people that witnessed it closely. These people fall in a number of categories, and I list those categories. These are the proponents of state capture who directly benefited from the capture. I say these are the main actors. I talk to persons who assisted the actors knowingly and benefited indirectly by being appointed to positions that they did not deserve, earning salaries that they did not deserve, or being afforded privileges that they did not deserve, like coal and overseas trips, local and overseas trips, and the supporting acts. I talked to persons who watched the state capture unfold before their eyes and did nothing about it, or looked the other way, and also a person who took steps to fight the state capture. And I call those the villains to the capture. And I do regard myself as one of those. Now, the only people, in my view, that have come and can come to the commission are those that are regarded as villains, right? By the main actors and the supporting acts. The overwhelming majority of these people are people who were pushed out of their jobs and have been rendered lepers by the stance that they took against capture. Because capture is a collusion between the public sector and the private sector, both sectors regard these people as dangerous and refuse to touch them. It's a reality, Chair. It's been there, we know about it. So when I first came to the commission, I was regarded as a villain. I was still employed at PRASA, so I came into the commission being an employee of an organization I was giving evidence about. At the time, after a number of attempts to push me out of PRASA for spurious reasons, Chair, they failed, obviously. I still was employed at PRASA and protecting the interests of PRASA from enemies of PRASA, both inside and outside. Now, what happened to me, Chair, is that on the 29th of January this year, the board of PRASA, and I must state that the current board is only 4 months at PRASA, and the acting group CEO of PRASA found another spurious and unlawful reason to push me out of PRASA. The approach that they took was simply to write a dismissal letter on the 21st or the 29th of January this year, so that I then can be forced to use my resources, which they've blocked anyway, to fight against this injustice, whilst they use the state resources, to maintain their unlawful act. And I think this is very critical for me, Chair. It goes really to the heart of what one is experiencing right now. I say further, nothing prevented the board from affording me a hearing before taking this drastic decision. However, affording me a hearing had an inherent risk in placing a spotlight on the unlawfulness of their action. They could not afford this. So the easy way was to conduct a review of my contract of employment themselves and find a clause and a policy that is nowhere in my contract and of a policy that does not exist in PRASA to dismiss me with immediate effect on the basis that my contract had expired. In fact, what they said is that it expired in 2019. The day after my unlawful dismissal, what they did, Chair, is that they reduced PRASA to an organization which, in my view, suffered from an inexplicable bout of bitterness against me. They launched a smear campaign against me. They issued media releases that said that my contract had lapsed a few years ago. I was aware of this, and I didn't advise PRASA accordingly. I mean, I'm a legal person, I don't have to say much on that. In my position, I was expected that in my position as the head of legal, I was to tell the organization that my contract had expired, and I hadn't done so. So therefore, there were issues of distrust. Then they go further, Chair, and they accuse me of having unlawfully approved a transaction of an amount, a payment, in fact, they say, of 58 million rand to a company called SA Fence and Gate. Mr. Montana talks to this thing in his affidavit. I've dealt with it. Unfortunately, we've not had an opportunity to deal with that. And also what they say is that my suspension by Mr. Montana was lawful. Now, you'll recall, Chair, I dealt with this, and I'm not going to go through this. And I say to you, Chair, that the above are all not true.
Sorry, did you say the current board?
The current board, Chair.
Which you say has been at PRASA 4 months.
Yeah, it's 4 months.
Was saying your suspension by Mr. Montana
was lawful.
A number of years ago.
Was lawful.
Was lawful.
Yes.
Why did they have to go back to the issue?
Well, Chair,
or do you understand or do you not understand?
Yeah, I don't know, and this is why I'm saying, the bitterness evoked this thing which they couldn't hide within them, and therefore they felt that they even needed to go back to, all those issues.
And they were not there at the time.
And they were not there at the time. They were not there.
They don't know the facts.
Yeah, they don't know the facts. They've never asked me. They've never engaged me. My view, Chair, and as a strong view that I have and a belief that I have, is that they have been engaging with Mr. Montana. Because all these issues are issues that arise out of the affidavit of Mr. Montana, to which I have responded, and they've never bothered to ask me or communicate with me in any respect. But they went to the public. And my view is that the issues that they were raising in any event at the time were not in the public interest. They terminate my contract, and they say I've overstayed my welcome at PRASA. I'm not sure why that is in the public interest, because what then happened is that the first opportunity that the media had as a breaking story, this was reported, to say the head of legal, PRASA, and all this thing. It's out there in the media, and they defamed my character when they did that. Now, the reality, Chair, is that, when an organization like PRASA sends a statement like this to the media, they'll latch onto it, and this is exactly what happened. So it was a breaking news on the Saturday of the 29th, 30th of January. Now, I do say at the time they released this thing, the board had been there for 3 months, right? They'd interacted with me, Chair. I was a member of some of the subcommittees of the Chair, of the board. They also invited me in my capacity as the Group Executive of Legal Risk and Compliance into the board meetings. So I sat there. And what I also did is that as part of the reporting to the board, I would report on litigation matters which I dealt with. Fence and Gate was one of them, the one that they're accusing me of having paid or advanced payment for. So for me, that media statement clearly reflected that they hadn't even bothered to read the reports that I had sent to them. But be that as it may, Chair.
Okay, just 1 second. Mr. Soni, we've got to see how this should be handled, because I think while it's quite fine that Ms. Ngoye can talk to the Commission about the challenges that whistleblowers face, because that's a very important part. But to the extent that...
Sorry, Chairperson, can I? I've been
they
asked
can't
to
hear me.
ask- Yes.
Okay. To the extent, or maybe let me start so that they can hear. I was saying we need to look at how to handle this. Absolutely. Because while it is important that the Commission gets to know whatever challenges whistleblowers, face, because maybe some of the things that the Commission is looking into might not have happened if there was a proper environment for whistleblowers and proper protection. And it may be that the Commission will need to make recommendations with regard to the protection of whistleblowers to the extent that her statement might be making certain accusations against certain people. The question would be whether we have notified them.
Yes.
You see, so it may be that it's something that we should hear, but after they have been notified that she will be here on a certain date, and she will talk about the challenges that whistleblowers face, and in the course of addressing that issue, she will implicate them in certain things.
Sure.
Yeah, so maybe we should do it that way. So you ought to get another opportunity, but after this due process. What do you think, Mr. Soni?
Yes, Chairperson. With respect, we hadn't thought about it. I didn't understand that persons would be implicated. I thought it was going to be a general statement.
Yeah.
I hadn't seen the statement.
Yes.
But with respect to Chairperson, you're absolutely correct.
Yeah.
We don't want to be accused of the same thing that they are being accused of acting procedurally unfairly.
Yeah. So basically, we are interested in hearing those challenges, Ms. Ngoye, but just to do the due process, and so arrangements will be made for you to air this properly.
I understand, Chair.
Okay, all right.
And thanks for the opportunity. I think it's important because
Yes.
it is what it is.
You are directly involved.
Yeah.
So sometimes it's when you are directly involved, it's not the same as when you are at distance away from the
Sure.
situation.
Yeah.
Okay, all right.
Thank you, Chair.
Okay.
Chairperson, then the process as far as this issue goes will be, we will get a copy of Ms. Ngoyi's statement and serve it in terms of Rule 3.3
Yes.
on the different implicated persons.
Yes, no, that's fine.
Thank you, Chair.
Ms. Ngoyi, Mayor, just to finish that though, your matter came up before the Labour Court as an urgent application, is that correct?
That's correct, Chair. This is unlawful dismissal. We brought an urgent application. Yes, Chair.
And you haven't, all that's happening, all that's awaited now is the judgment of the court in that matter.
That's correct, Chair.
All right, Ms. Ngoyi, then in regard, and let me apologize that these matters are, these things are happening to you. It won't be fair for me to say that they are attributed to your being here because I would be prejudging the situation. But I just express a concern that it is happening to somebody like you.
Thank you.
Can I ask you then?
Do you remember to speak up a bit?
Oh, sorry. Sorry, Chair.
Yeah,
Yes.
I couldn't hear some of the words.
Oh, okay.
Yeah.
I was, person to person, I was saying to Ms. Ngoyi that I was sorry that somebody like her is facing this without saying that there's a link between the fact that she gave evidence and what has happened, because that still is a matter that would need to be determined.
Okay.
Now, Ms. Ngoyi, in regard to the matter you are going to testify today, you have made an affidavit, and that appears at bundle E2, starting at page 656 and ending at page 657. Is that correct?
That's correct, Chair.
And that affidavit has an annexure, which is a memorandum which contains much of the contents of the evidence you are about to give today.
That's correct, Chair.
All right. Now, in regard to the affidavit, do you confirm that what's contained in the affidavit is true and correct?
I do, Chair.
And in regard to the memorandum itself, do you confirm that what's contained in there is true and correct?
I do, Chair.
Chair, may I ask leave for Ms. Ngoyi's affidavit to be admitted as SS7, and it'll be placed in bundle E2.
The affidavit of Ms. Onika Martha Ngoye, starting at page 656, red numbers, is admitted together with its annexures as Exhibit SS7.
As you please, Chairperson.
Yeah, okay, thank you.
Now, Ms. Ngoyi, can I just ask, that so that it's properly identified, you've made 4 other affidavits before the Commission, am I right?
That's correct, Chair.
Chairperson, just to distinguish it, instead of simply saying SS7, we call it SS7E, because they are the previous ones. I'm told now that those...
Are they SS7 A, B, C, D?
In terms of the new index we've been given, that's how it is. And I think that index is in your bundle as well, Chairperson.
Yes, but were they admitted and given that label?
No, that's why I didn't want to introduce something that was not there.
Yes, because it could cause confusion.
Absolutely, Chairperson.
Well, do you know whether there is SS 7.1? Because if there isn't, maybe we can make this SS 7.1.
There isn't an SS 7.1, Chairperson.
Okay, shouldn't we do that?
Yes, that would be preferred.
Then we'll refer to SS 7.1.
Yes.
So the affidavit of Ms. Onika Mathangoye, which starts at page 656 of PRASA bundle.
E2.
E2 is admitted as exhibit SS 7.1. So I'm correcting the previous exhibit number. I said earlier it would be exhibit SS 7, but I'm now amending that it will be exhibit SS 7.1.
As you please, Chairperson. Now, Mr. Ngoyi, can I just ask, as regards the memorandum, which is Annexure 1 to your affidavit, can you briefly tell the chairperson how it came about that that memorandum was compiled?
Chair, one of the issues that the board, the current board, as I indicated, it's a new board at PRASA, wanted to understand and get clarity on was on the appointment of worksmen. In fact, who had appointed worksmen, what processes were followed when worksmen was appointed, and what the involvement of the legal department were or was in the appointment of worksmen. The understanding that was that at least I got from the questions that were raised by the board was that perhaps also the legal department had played a role in the appointment of worksmen, and we sought to clarify that and indicate our involvement as the legal department, in the investigations and how it came about that we, as the legal department of PRASA, became involved in the investigations themselves. In fact, Chair, if I may say, we've done this report for all the other previous boards. In fact, that's one of the first things. A lot of the boards have come in and have said, we want to know, give us the worksman's report and the appointment thereof. So this is the basis of this report where the board said, put it down in writing and tell us what has transpired.
Now, in the memorandum, and the memorandum is dated the 21st of December 2020, is that correct?
That's correct, Chair.
Who compiled the memorandum?
Chair, I compiled this memorandum together with Mr. Fani Dingeswayo, who was the general manager of legal at the time. He has since left the organization. So because we've been dealing with this matter, the both of us, throughout, so we compiled it together and sent it to the board.
Now, Mrs. Dingeswayo has given evidence before this commission as well.
Yes, Chair, he has.
Is he still employed at PRASA?
No, Chair. In fact, he left on the 29th of at the end of January.
All right. Now, in paragraph 2 of the memorandum, you point out that as regards the appointment of worksmen, there were two. Sorry.
Mr. Soni, we'll just have to be consistent whether we call it a report or we call it a memorandum.
Yes.
Otherwise, whoever reads thinks you are referring to another document.
No, sure.
Yeah.
It is headed memorandum, so perhaps we should stick to that, Chairperson. So in this memorandum, in paragraph 2, you refer to 2 other investigations regarding the appointment of worksmen. As you would have heard the chairperson say, the facts are not in dispute. We needn't go into details, but what were those 2 appointments, those 2 investigations?
Chair, the first investigation was done by the Auditor General when they were doing their audit. And the second investigation, in fact, was commissioned, it's not so long ago, it was done by the SIU, where I think it was part of the proclamation that was issued by the President to have Worksman's appointment also investigated in there.
Now, in paragraph 2.2, you say that the AG had found, that's the Auditor General, had found that the appointment contravened Section 217 of the Constitution.
That's correct. That was the finding that was made by the Auditor General.
Now, I'm just placing on record that in his affidavit, Mr. Hotz disputes that. That's, of course, a legal issue. I'm just placing it on record because he may not get a chance to come before the Commission, or he may choose not to come.
I've read Mr. Hotz's affidavit, Chair, so I'm aware of it.
Okay. And do you know what's happened to the SIU investigation?
I don't, Chair. In fact, I mean, we were also investigated by the SIU, in terms of our involvement. And so we gave our evidence to the SIU, and we've not heard since as to, where the matter is. So I'm not sure if it's been completed or not.
When did the SIU start its investigation? Or when did they interview PRASA people such as you?
Yeah, they started in 2020, Chair. This was when the administrator was at PRASA, and the momentum, I suppose, of the particular investigations took place, and that's when they started interviewing us.
Okay.
Now, you then set out in paragraph 3.1 how it came about that Werksmans had been appointed.
Yes.
That's the history.
Yes.
Now, just again in terms of context, at the time Werksmans were appointed, as I understand it, you and Mr. Ningazwayo were on suspension.
That's correct, Chair.
So that information that you are giving, you set out at paragraphs 3.1 and 3.2, is based on what you'd been told by different persons.
Well, some of it is, Chair, and some of it is what I know, because we came back from suspension. I think I came back on the 27th of July, and Worksman's letter of engagement was signed on the 6th of August. So I am aware of, that process, but in terms of what had transpired before, I had been told to say this is what the board had decided and this is what happened.
Did they start their investigation before the letter of engagement?
No,
or
no, no,
they
they
didn't.
didn't.
They only started after?
They started after, Chair.
Okay.
Yeah.
Go in annexure BBH 90, perhaps I should just place this on record. Mr. Hotz has filed an affidavit, which is with the commission, or it's one of the documents before the commission. It hasn't been admitted yet. It is Exhibit SS 25, and it appears in Bundle M. Now, Mr. Hotz, in paragraph, in annexure BBH 19 to his affidavit, sets out how that came about, how the appointment came about. If I could just briefly tell you what I understand the version to be, that in fact it is correct that Ngubane was earmarked first to do the investigation, but certain developments took place which resulted in the fact that Werksmans were appointed. Now, I'm just asking you in terms of you've looked at that. Does that fit in with what you understand the facts to be?
Yes, Chair.
So you accept the correctness of what's contained in BBH 19?
Yes, I do, Chair. And so far, obviously, as it relates to the time frame, that I was involved, I do accept that.
You see, there is one important issue, and I just say it's important, is Mr. Hotz wants to stress that there was never such a thing as the Ngubane consortium. He is saying that their appointment effectively replaced the appointment of Ngubane in the circumstances described in his affidavit.
Yes, Chair, that's what he says.
Well, I don't want to be unfair to anybody, but when I read Mr. Hott's affidavit, I don't know whether somebody else's affidavit, it kind of gave the impression that Ngubane and them may have been aimed to be appointed for the project, but Werkmans came into the picture and kind of pushed them aside. And then they were appointed. It might be unfair. I'm just saying, when I was reading, it looked like this whole idea of attorney-client privilege may have been used.
Yeah. Chair,
I may be unfair to them.
Sure. And my understanding, and I guess Council is asking about the Ngubane consortium, because I think we had referred to there being an Ngubane consortium, I think in our speak, because we had understood that the entire team initially started as part of the Ngubane consortium, because the initial letter that was signed for this particular investigation was with Ngubane. And what we understood was Ngubane would then bring in other subcontractors, and Worksmans would be one of them. But obviously, we were then told, no, that was not the case. In fact, Ngubane was appointed first, I think around about the 24th of July in 2015. And then, with further discussions that happened, Worksmans was introduced into the team. And because of that, the legal privilege, as you say, attorney and client privilege, they were not necessarily kicked out. They remained as part of the team, but the lead was then taken by Worksmans.
Yeah, they became a subcontractor or something.
That's right. So
it certainly came across to me when I was reading as if the attorney-client privilege may have been used to make sure that the Workmans became the leader. But as I say, I may be unfair to them.
yeah, I think Mr.
Right or
Hudson
wrong, that's the impression that I got. And it may well be that there is a lot of weight that should be attached to attorney and client privilege in these investigations, but I'm not sure. But I was just saying that's the impression I got. It may be a wrong impression, but it just came across as there is an accounting firm or a firm that was going to be given the work and to lead. And then there was this big white law firm that came in. Initially, maybe it was going to be a subcontractor.
Yeah.
And then the issue of attorney-client privilege came in, became prominent, and they ended up being the leader.
Yeah. So let me explain, perhaps just to give a bit of context as well. When, at least what we were told, is that Regulation 16A of the Treasury regulations was used to appoint Ngubane by the board. But this we were speaking to the company secretary as he was giving us feedback on what had transpired. So we then indicated that Regulation 16A does not apply to PRASA, and the process that the board would have followed in appointing Gubani would not have been correct. And then, and I think at the time that we got it, Worksman's and the other subcontractors were already, part of the discussions. And the question, and I do allude to this in the report, to say the question that then came back to us from the board was whether Worksman's was on the panel of PRASA's legal attorneys. And we confirmed that because Worksman's had been doing work with PRASA at the time. So that's how effectively, I think perhaps maybe, I don't know, I'm just also, saying this is how I understand it happened.
Okay, Mr. Son.
Yes, you please. Certainly from the letter Mr. Hotz wrote, and that letter, which is BBH 19, is addressed to the SIU following a meeting between Worksman's and the SIU relating to this very issue.
That's correct, Chair.
And he makes the point you made, namely that 16A didn't apply, a Treasury Regulation 16A didn't apply, and therefore the appointment of Ngubani would have been invalid. But I'm just saying that it's also contained in this letter.
That's correct, Chair. That's what the letter says.
All right, so that's the appointment.
I'm sorry. I'm just going to go back to the issue of attending client. We don't need to spend too much time on it. And I know that you are testifying as somebody who was head of legal. And I guess that you would have experience of other investigations being conducted at PRASA by other entities at some stage or another.
I think this was the first one, Chair.
Oh, was it the first one?
Yeah, this was the first investigation that I had to be involved or that I experienced at PRASA.
Yeah.
The other ones I wasn't.
Well, I'm just wondering at what stage the issue of, I mean, now you investigate matters of corruption. If you find that there is prima facie evidence of certain people having been involved in corruption, that's going to be handed over to the law enforcement agency. So why is attorney-client privilege important?
Well, Chair, I guess, from the understanding that I have, Chair, is that obviously when you deal with, and I understand what you're saying in relation to law enforcement agencies, that would have been an expectation anyway in terms of the law, to say if you find anything unlawful, you have to report it. But in relation to other matters, perhaps that were confidential, and that the board might not necessarily have wanted to be communicated or expressed out in the public before finalization, and I'm assuming, Chair, this is the scenario, that the attorney-client privilege, would work. And I think, clients find comfort.
Work against whom?
Sorry, Chair.
I know I'm not cross-examining you.
Yes, yes.
I'm just trying to understand, because if you are asked to investigate allegations of corruption, you are going to interview witnesses, you are going to interview implicated persons, and you'll prepare a report on the basis of that.
Yes.
And the idea is that if there are, and this is a public entity, this is not a private company.
Yes, sure.
This is a public entity. If there is money that's been stolen, it's taxpayers' money.
That's right.
So you are going to take your report, give it to the board, but as far as you are concerned, whatever is in your report about acts of corruption should go to the law enforcement agencies. So who is going to invoke attorney-client privilege? For whose benefit is attorney-client privilege in that case? Because the board should be wanting that your report should be handed over to the law enforcement agencies and the statements or affidavits that you collected from people and the exhibits and so on.
Yes. The way I understood, I mean, as part of it, and also from a client perspective, clients, I guess they do find comfort with the fact that they do have that protection from attorneys. But also, the investigation involved, obviously, employees being investigated and names of people in the reports and so on. And what I had understood is that at some point, some of those employees were not necessarily advised, for instance, let's say, of their names going to be communicated elsewhere. And for that protection as well, in terms of that information, until all the I's were dotted and the T's were crossed in relation to the investigation. I know this happened because there was a time when the board, I think, had to present to Parliament, and the names of the people that were in the reports could not be released because, the investigations had not been completed. And the board did advise that, they were not able to do so, and the attorneys obviously advised accordingly as well until the rights of everybody was protected.
Yeah, well, all right. Maybe at some stage, one would have clarification,
Sure,
but it's fine. Let's proceed.
As you please, Chair. Then, in paragraph 4 of your report, you deal with the involvement of the legal department, or perhaps the limited involvement of the legal department. Can you briefly summarize what the legal department's involvement was?
Yes. So when we got back from suspension, as I indicated, the horse had bolted in relation to the decision to conduct a forensic investigation by the board. So effectively, what we were asked was to look at the terms of engagement of the respective parties who were going to be part of the relationship. And that's where we came in as the legal department in fact, I think at one point we had met with Ngubane to try and see if we can assist finalizing, not aware that there was already a letter of engagement that was signed. But when we came in, we were, told that Ngubane is going to obviously be the lead, and there was going to be a letter of engagement with Ngubane. So we were coming in and we're still trying to find ourselves as to what was happening. But it so turned out that no, a letter had already been signed, by the CEO at the time. And we then were now, engaging with, we were then instructed, in fact, by the board to say, this particular transaction is going to happen, and we have a letter of engagement that needs to be finalized with Worksmans taking the lead, and we need you guys to review as the legal department that letter. And that's basically, was our involvement in looking at the terms of that letter of engagement and trying to negotiate, the terms, because what we understood as the legal department is that if you have a project as big as the one that was basically going to be given by Worksmans, you approach it differently in terms of, the fee structure and so on, because it's not just a simple transaction where you give one instruction to an attorney and, they charge you accordingly. So that was the mind frame that we had to say, well, look at this letter of engagement, go in on that basis, and that's effectively what we did.
Ms. Ngoyi, at paragraph 4.2, and I just ask this for clarification's sake so that when Ms. Manasseh gives evidence, we know that whether we are talking about the same occasion. At 4.2, you say a subsequent meeting was arranged within Ngubane, and the meeting included the different people. Now, in her affidavit at paragraph 9, Ms. Manasseh says, Chairperson, you needn't go there, I'm just so that when it comes up. Ms. Manasseh says there was a meeting on the 27th of July. Is that the meeting you are talking about at paragraph 4.2?
Yes, it could be the meeting, yes.
Well, I'd like it to be checked so that when Ms. Manasseh, you see, she
sorry.
says,
Okay, Chair. Can I ask to be taken to exactly what Ms. Manasseh is saying so that I know I'm
yes,
talking to?
she says, on the 27th of July, the chairman of the board and myself met with the forensic team led by Ngubane. The purpose of the meeting was to discuss the scope of the investigation and so on. And then she says, in this meeting, one of the forensic team members introduced us to Werksmans. I attach a document, Annex Year 2, which is a letter from Werksmans to Mike Koya of the SIU. And that is the letter I just read to you.
It was not the same meeting, Chair. So when we had the meeting with Ngubane, the chairperson of the board, as well as Ms. Manasseh, I don't recall them having been part of the meeting. So that would be a separate meeting that we had, because the 27th of July would be the day that we came back and back to the office. And so we were not involved in any meetings on that day.
So you were not present, because
No,
that's
Chair.
her point.
Yes,
So
no.
that is a separate
It
meeting.
is a separate
Okay.
meeting, Chair.
Okay. All right, sorry, then what was the outcome of the involved, or how did the legal department at PRASA become involved?
Well, as I indicated, Chair, we were meeting this team for the first time, and we're trying to make sense of who is who and what is happening in terms of this particular transaction, because also the basis of our involvement was really around, being able to settle the engagement letter, because we understood at that time, in any event, that there was an identified person within PRASA who would be working on the investigations, and it was not necessarily the legal department. So our role effectively was just to try and understand the terms of this particular team, who was who in the team, and how everybody, what role each party would play.
Now, at paragraph 4.5, you say that in regard to the amount to be charged for fees, Ms. Manasseh said that if you want quality work, you don't negotiate fees.
Yes, Chair, she said that to us.
Now, sorry,
yes.
carry on.
No, she did say that to us. In fact, we had started the negotiations at the time with Werksmans. And I guess as part of the report back to her, we then said, look, one of the things that we're negotiating with Werksmans was the fees. And she turned around and she said, no, you guys can't negotiate the fees. The amount, you can't expect to receive quality advice if you're not going to pay, what the fees are supposed to be. So, we kind of thought, okay, suppose it is what it is.
Can I ask you this? Well, let me put her version, and I'm summarizing. She says, when the question of fees came up, she said to you that she is aware of fees that accountants charge. And you, as a lawyer, would be familiar with the fees that lawyers charge. And it is for you to determine whether those fees were reasonable. But she disputes making that statement.
No, I don't agree with her, Chair. I'm very clear, and I do remember, and we've repeated this point ever so often to say, no, that's not what you said to us. Yes, you did speak about the fees relating to the auditors, because it's a regulated amounts. But when it came to us saying this is what we are doing as well as part of the negotiations, she basically told us not to deal with the fee element.
Can I ask you though? You were asked not to deal with the fee element.
That's correct, Chair. That's what she had said to us.
Now, but you were aware of what fees had been agreed. Those fees, you say, were between Ms. Manasseh, Mr. Molefe, and Werksman.
Well, effectively, Chair, in terms of the engagement letter, we got to see the fees. And I don't think, there was a change, because one of the things that we had identified, we looked obviously at the categories and what each partner, for instance, would charge and so on. And there was a point where I think Worksmans had limited their directorship to 10 years experience, and I think they had a number of years. So we requested them to actually, combine those number of years to charge, even if it's a 15-year director, to charge the same fees, and not necessarily increase their fees because of the number of years. So that discussion had happened, at the time that we had spoken to Director Manasi. So I guess in the engagement letter, it remained as such, and we just continued.
So are you saying that discussion had happened in a different context?
In a different, yeah.
With Workmen's?
Yes.
Okay.
So
But you say that whatever they had agreed with you on that occasion,
It
you
remained.
don't think it had changed
No.
when this happened?
Sure. Yes.
And you were comfortable with the earlier arrangement rates?
What
that
we
were
had
agreed?
agreed with them. Yes.
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 And you say, ultimately, when you saw the letter of engagement with regard to this investigation, the
hadn't
rates
changed.
appeared to be the same.
It hadn't
The rates,
changed.
It had not changed.
Well, it had taken our comment.
Yeah, into account.
That's it, Chair.
Okay, so that although Ms. Manasseh might have made the
That
remark
comment,
she made,
yeah.
in the end, you didn't have a problem with
No, we
the
didn't.
rates, yeah?
No, we didn't.
Okay,
Yeah.
all right, okay.
And in addition to not having a problem with the rates, was it your view that the rates were reasonable, or would you, if you had negotiated different rates?
Well, Chair, in light of, what, as I indicated before, our approach, and this is what we discussed with Worksmans, our approach was, when you work with attorneys in transactions of a huge nature, and we took it that this is one of them, you would negotiate reduced fees, to say, look, guys, you're getting a lot of work, and really you can't expect us to be paying the same fees that you would normally charge a client. And I stand to be corrected. I think that some of the rates were changed, but I can't remember which ones. But the Worksman's team took that into account because we pushed very hard on that, and they took it into account in relation to, charging us also for some of the things that were there. So what we then ultimately received for us was a better rate that it was before, the letter was finalized.
And it's a rate you were comfortable with.
That's correct, Chair.
When I say you, it's the legal team.
It's the legal department, that's right, Chair.
Now, in regard to the reporting from Worksmans, how did that work? Because you addressed that in paragraphs 4.7 onwards.
I'm sorry, Mr. Sonny, we are at 1:02.
Yes, I'm sorry.
So let's take the
We'll
lunch
take the
break,
lunch.
and then we'll resume at 2 o'clock.
As you please.
We adjourn.